Hello friends, you all must be aware of the difference between judicial activism and judicial overreach. And the same issue is in news back again because President Draupadi Murmu challenges Supreme Court's verdict on the bill assent deadlines. So, India's constitutional framework is in the spotlight again. The Supreme Court set hard deadlines for governors and the President to decide on new laws. Now, President Draupadi Murmu has formally asked the court to clarify if that is even constitutional. So what did the Supreme Court rule? On the April 8th, under Article 142, the court said that governors must act on the state bills within 1 month and the president on the reserved bills within 3 months. And if the deadline is missed, the bill will instantly be deemed as assented. As you can see here in this news article, President reference questions if judiciary can impose such timelines for the president under the Article 201. So why is the president objecting? President Draupadi Murmu argues that Articles 200 and 201 say nothing about timelines or procedures. She has used Articles 143 to pose 14 pointed questions to the Supreme Court, challenging whether courts can impose their own deadlines on these constitutional offices. So what are some of the key questions posed? First, can the judiciary fill constitutional silences by prescribing time limits? And second, do governors and presidents have any real discretion or must they blindly follow ministerial advice? And if deemed assent is valid if no action is taken, does this upset the separation of powers and federal balance? Well, where does all of this emerge from? The Tamil Nadu trigger. This all started with Tamil Nadu's assembly overruling its governor who had withheld bills for over a year. That dispute went to the Supreme Court and sparked today's clash over the constitutional authority. So what are the constitutional stakes? If courts can mandate deadlines, they effectively direct executive functions, traditionally the realm of governors and ministers. Well, critics warn that this could blur the line between judiciary and executive. So what is next? A bench of 5 or 7 justices will examine the president's reference. Their advisory opinion won't be binding law, but it will guide future disputes and may even prompt constitutional amendment. Now, why does all of this matter to us? This debate is not just about legal theory. It affects how quickly new laws take effect, how state governments function, and how Bharat balances power amongst its institutions. What do you think courts should have this power, or should executive discretion remain untouched? Drop your views in the comments, like if you learned something new, and subscribe us for more updates. Thank you. Jai Hind, Vande Mataram. Abhyas IAS Super 30 batch starting from June 15th. Take the skill test and join us in clearing your civils in your first attempt itself.